Call the meeting to order. This is meeting number 49 of the Standing Committee on Justice and Human Rights. And for the record, today is Wednesday, February the 16th, 2011. This meeting is being televised. So you have before you the agenda for today, and we're continuing our review of Bill C-54, an act to amend the Criminal Code, sexual offenses against children. So after we hear three witnesses who are before us right now, we'll move to clause-by-clause consideration of the bill. Now, before we move forward, two items. We received communications from a witness who testified at last Wednesday's meeting with a clarification of his status. Mr. Randall Fletcher was shown on the meeting agenda as representing the Office of the Attorney General of Prince Edward Island. And you may recall that the chair sought to confirm his representation of the AG during Mr. Fletcher's testimony, at which time Mr. Fletcher appeared to confirm that he understood that his presentation had been reviewed by the minister. Now, last Thursday, Mr. Fletcher sent a clarifying note to the clerk, and I'll reread it verbatim. Prior to my video conference presentation to the Standing Committee on Justice and Human Rights yesterday, I advised the person I report to about the request to present. I was not certain if this was being passed on to the minister and had not had a chance to pursue the matter before the presentation. When I was introduced as representing the Department of the Attorney General for PEI, I thought perhaps there had been some communication to that effect, as I had not represented myself as doing so in my own communications. As of this morning, I believe that the matter was not put before the minister and would like to clarify that the opinions I expressed in the session may or may not represent those of the department. I will attempt to get further clarification on this, but do not want any current misunderstanding to continue. So that's the end of his quote, and so that's just for the record. He wanted us to ensure that that was on the record. The second item before we move to our witnesses, you have before you the 8th report of our Subcommittee on Agenda and Procedure of the Standing Committee on Justice and Human Rights. Now, at that meeting, we simply settled on moving next to Bill C-4, the Youth Criminal Justice Act amendments, and it was agreed that we were going to ask approximately 21 witnesses to either come for a first time or to return for further testimony. And we've agreed that the panels consist of no more than 3 groups apiece per hour. So that's your 8th report. I believe it accurately reflects what we settled on there. Do we have a mover for that report? Monsieur Lemay. All those in favor? Opposed? Motion is carried. All right, moving to our witnesses. We have with us, representing Statistics Canada, we have Julie McCauley, as well as Craig Grimes, and also Mia Doverne, all coming back to testify. So you know the process. I don't know if you've prepared remarks. If you would like to start, and then we'll open the floor to questions from the members.
Thank you very much, and thank you for the opportunity to present to the committee on the Act to Protect Children from Sexual Predators. Statistics Canada does not take a position on the bill. The presentation we have prepared contains our most recent data on the sexual offenses committed against children that are the subject of this bill. They include only the sexual offenses against children that have come to the attention of the police and the courts. The version we are presenting to you today differs slightly from the advance copy you received. During the verification process, we noticed an anomaly with data received from Quebec, which has been corrected. Slides 4, 5, and 6 of the presentation were affected. All data sources used are clearly indicated on the slides, as are any pertinent data notes. My colleagues, Ms. Mia Doverne and Mr. Craig Grimes, will help answer any questions. If you would please turn to slide 2 in the presentation. Using data received from police services across Canada, we can examine trends in police-reported incidents of sexual offenses committed against children. Over the last 10 years, the rate of overall police-reported sexual offenses committed against children has remained relatively stable. Sexual offenses committed against children can be grouped into 2 categories: sexual assault and other sexual offenses. The rate of police-reported sexual assaults committed against children has been generally declining since 2005, while the rate of other sexual offenses committed against children has increased in the last 2 years. On slide 3, we can examine the geographical variation in the rates and number of victims of police-reported sexual offenses against children. In 2009, the highest rates of these offenses in Canada were in the north. While rates are used to ensure that trends are not biased by variations in populations, it is important to note that the number of incidents of these offenses in the north is considerably lower than in most provinces. Slide 4 provides an overview of the ages of police-reported sexual assaults against children. In general, for police-reported sexual offenses committed against children and youth, we know that females are more likely than males to be the victim and that teenage girls are the most at risk. This finding holds true for victims of police-reported offenses of child sexual assault. In 2009, more young females than males were the victim of police-reported... Oui, certain.
Parce que la traduction, elle peut pas suivre.
Oh, okay.
Because you're talking too fast, could you slow down, please?
Females aged 12 to 17 being the victims than those in other age groups, whereas the number of incidents of boys remained relatively stable regardless of age.
Ah,
Right.
bon, là, on l'a. OK.
I think the witness knows she has to slow down.
Non, mais c'est parce qu'on n'avait plus la traduction.
That's because the mic was turned off, and so it's back on now. Thanks.
Please proceed.
Okay. Slide 5 provides an overview of the ages of victims of police-reported other sexual offenses committed against children. While females are more likely than males to be the victim, the distribution of the victim's age is different from what we saw on slide 4 for sexual assaults. While the number of incidents for boys remained relatively stable regardless of age, the risk of victimization for girls peaked at age 13. The next 3 slides show 2009 police-reported data on the relationship between victims and those accused of committing a sexual offense against a child. As you will see, as children age, the accused-victim relationship generally shifts from parents and other family members being the most frequent perpetrators to acquaintances. Slide 6 focuses on children aged 0 to 5 years. Here we see that parents and other family members comprise the majority of accused persons. In 2009, almost 6 in 10 boys and close to 7 in 10 girls were victimized by a family member. On slide 7, we look at the accused-victim relationship for police-reported sex offenses involving children 6 to 11 years old. As you can see, while boys and girls in this age range were still most likely to be victimized by a parent or other family member, the proportions were less than those for younger children. In contrast, 6 to 11-year-olds, particularly boys, were more likely than younger children to be victimized by an acquaintance. In other words, the relationship is beginning to shift from family members to acquaintances. Slide 8 shows the accused-victim relationship for police-reported sex offenses involving children 12 to 17 years old. Here we see an even greater drop in the proportion of children who were victimized by a family member and an increase in those victimized by acquaintances and strangers. These data also show that teenage boys were about 3 times more likely than teenage girls to be victimized by an authority figure, such as a teacher or a coach. During the teenage years, we also see a substantial increase in the proportion of sexual victimizations committed by strangers, about 10% of boys and 14% of girls. Please turn to the next slide. The number of sexual assault and other sexual offense cases completed in adult criminal courts in Canada has remained relatively stable during the last 5 years. In 2008-9, there were approximately 7,400 sexual assault charges in Canada, which were contained in approximately 5,000 court cases. Sexual assault data collected from criminal courts does not permit us to differentiate between those committed against children and youth and those committed against adults. As a result, it is not possible to identify the age of the victims in sexual assault cases using data collected from adult criminal courts. However, we know from police-reported data that approximately half of sexual assaults committed in Canada in 2009 were committed against children. The vast majority of these were sexual assaults level 1. In 2008-9, there were approximately 7,200 charges of other sexual offenses contained in approximately 3,300 court cases. Cases involving child sexual offenses often include charges for other offenses as well. Slide 10 shows a proportion of guilty findings for charges of both sexual assault and other sexual offenses, regardless of whether this was the most serious offense in the case. In 2008-9, 32% of cases contained a charge of sexual assault and 48% of cases that contained a charge of other sexual offenses resulted in a finding of guilt. These proportions have remained relatively stable since 2000-2001. Slide 11 shows the difference in the types of sentences imposed for cases of sexual assault. In 2008-9, custody was the most serious sentence imposed in approximately 55% of cases involving sexual assault. This represents a slight increase from the year prior. While the proportion of conditional sentencing has remained relatively stable since 2000-2001, the use of probation has been decreasing. As we can see from the next slide, most custody sentences imposed in cases with a guilty sexual assault charge were for a term longer than 3 months but less than 2 years. The median length of custody for these cases was approximately 1 year. Since 2000-2001, between 23 and 27% of cases with guilty sexual assault charges involve sentencing to custody for 2 years or more, which is federal custody, compared with only 4% of adult guilty cases in general. These longer custody lengths may indicate the seriousness with which the courts treat these cases. Slide 13 shows the difference in the types of sentences imposed for cases of other sexual offenses. In 2008-9, custody was the most serious sentence imposed in approximately 65% of cases involving other sexual offenses. This is an increase over the year prior and a continuation of the upward trend seen since 2003-04. The use of probation has declined since 2003-04, and in 2008-9 was the most serious sentence in approximately 18% of cases involving other sexual offenses. The use of conditional sentencing has also decreased over the last 4 years. On slide 14, we see that the distribution of custody sentences for other sexual offenses has been changing since 2005. There has been an increase in the use of custody of a term of 3 months or less, and a decrease in the use of custody of longer than 3 months but less than 2 years. This change began in 2005 and coincides with the introduction of mandatory minimum penalties for several of the offenses in this category. Once again, thank you for the opportunity to present to the committee. This ends my presentation.
Thank you, and I'm assuming both Ms. DeVerne as well as Mr. Grimes are there as resource to answer questions. All right. We'll begin the questioning with Mr. Murphy. You've got 7 minutes.
Thank you, Chair, and thank you, witnesses. Very interesting report. I'm going to generalize that, and I'm going to thank you for the breadth of it in timing. And my generalization is that it's a fairly static. Most of the decks, the slides on the deck show a static situation with respect to just sex crimes, let's call them. But the questions, there's one question I have is a general one. There's been a lot of publicity, just hearing myself here, a lot of publicity about the unreported crimes. Now, you're Statistics Canada, so I'll let you answer it in your own time, your own way. But I suspect you can't really tell us what crimes are not reported. At least they're not in this deck. I'll let you answer that perhaps at the end, because I have more specific questions from your presentation. When we go to 13, page 13, 14, And I'll do one at a time here. There was an increase on page 13 of custodial sentences by a significant amount, 15. I'm going to say 15% or more after 2006. I'm going to guess it has something to do with some legislation, but you can maybe help me there. The green line spikes up. On page 14, you mentioned the blue line, which is decreasing. That's sentences more than 3 months and less than 2 years. Declines because of mandatory minimum sentences that were introduced in 2005. I think that's what you said. I guess the question I have is, you can clarify, but I want to know, you said it, but I'm not sure it got to me what the relationship would be. Can you explain that a little further?
So I'll start with your last one, and I'll ask Mr. Grimes to interject as needed. On that slide, what I said was that it coincides with the introduction of mandatory minimums. I did not say that it was a result of the mandatory minimums being introduced.
Is that because you can't say you say it coincides, but you can't say there's a relationship?
I cannot comment on the relationship between the statistics and the legislation.
We're supposed to figure that out, whether it is or not, or just a fluke or something.
I can only comment on the data.
I understand. And you're talking about mandatory minimums that were brought in 2005. The 14 days, or which mandatory minimums are you talking about?
Those would be the mandatory minimums brought in 2005, which were the 14 days, 30 days. So they're shorter mandatory minimums than some other mandatory minimums that currently exist in the criminal code.
I should know this, but a custodial sentence more than 3 months and less than 2 years might have been used before 2005 instead of a 14-day minimum. Is that possible?
Yeah, yes, it is possible, but prior to 2005, it would also be possible for probation or a conditional sentence to be a sentence for those offenses. But after 2005, conditional sentencing would not be a valid sentence.
A mandatory minimum is a custodial sentence, right?
Yes, that's
so
right.
it's probably represented in the green line, which is 3 months or less, right? That's probably what that is. If we're left to figure it out for ourselves, that's fine. I think that's what it must mean. Back to slide 13.
In terms of slide 13, again, the changes, Mr. Grimes can comment on exactly what legislation was introduced in 2006-07, but again, we cannot comment on whether what you see in terms of the increases as a result of the legislation.
What I can tell you about those lines and how they're changing. If there are mandatory minimums in place in 2005 and there are more cases going into custody and those mandatory minimums are short, then it's possible that you would see an increase in those shorter sentences, which would change the distribution that we're seeing in this chart on page 14.
Okay, I appreciate that. My first question was the general question on unreported crimes. There was if I don't have it here, I should have brought it, but I think it was from the MacDonald Laurier, I may be wrong, Institute. Anyway, can you give us any comment on how you measure unreported crime?
Certainly. Unreported crime is measured by Statistics Canada through the General Social Survey on Victimization. That is a survey of Canadians aged 15 years of age or older. 8 specific offense categories are asked. Based on the results that were released earlier this year, we know that 1/4 of Canadians 15 years of age or older reported being the victim of a crime in the 12 months preceding the survey. Just under 1/3 of the Canadians who had been victimized reported that victimization to the police, and that's slightly down from 2004. Now, one thing that we do need to keep in mind with these data is that it is the individual's perception of the situation. It has not been an offense that has been substantiated by the police.
Okay. Frankly, those are the questions I had. I don't know if Mr. Lee or Madame Jennings wants to take up the rest of the time.
All right.
There?
No.
Okay, we'll move to Monsieur Menard.
First of all, I'm sorry I was late. I really made the best effort to get over here at the end of question period. There were journalists who just absolutely wanted to have an explanation of what happened at the committee last night. And meeting with people who worked on this issue, and to the time to get here, this is quite a distance from the Hill. But also, I saw this deck for the first time when I got here, and even if I'd had it, it's impossible to really get a fair idea of the significance of all of these data. And at the same time, I give them a lot of importance. I'm confident in Statistic Canada. I know that's one of the best organizations in the world. And I often read its publications. But these kinds of statistics can't be read in the way that you've just read your presentation to us. You look at them, and if not, you only retain certain aspects of it. So I would have liked to have had this in advance. I don't know if my assistant received it yesterday, but yesterday I was in meetings until 10 at night before the committee. So I think when we ask you to come, I think it would be wonderful if you could send them in with some advance. So I just don't know how this is going to help me today in the votes that we're going to have this afternoon, and it's really unfortunate. Having said that, I did look. We were told, and this is coming from a defense lawyer, that the courts had set out the principle that in terms of sexual offences against children, the rule really was a custodial sentence. I have the impression that I'm not seeing that in your statistics, so can you speak to that, please?
The sexual offenses against children that we can identify in the courts are identified on page 13, which shows the most serious offenses in cases containing one of those offenses that have been found guilty. And you'll see the top line, which is the increase in the use of custody for those types of offenses. And in 2008-09, it's approximately 65%, which is it is quite a bit more than what you see in criminal court generally, which is around 34% for use of custody.
Quand vous dites 34%, en général.
Well, when you say 34%, you mean for other categories of offenses?
In criminal court. Now, I can provide a more detailed breakdown of that if you would like.
Oui, mais je vous comprends bien.
Well, I understand. You're saying that in sentences that are handed down in general in Canada, 34% involve a custodial sentence. That's what you're saying.
Tandis que quand c'est
Whereas when it's for sexual offenses, it's an issue of sexual offenses. You're speaking about page 13, but I am seeing in other sexual offense cases in adult criminal courts. So what I wanted to know was if your statistics confirm the opinion that the defense lawyers expressed here before us, that the courts had established that when it was an issue of sexual offenses against children, the rule was a custodial sentence. That's not what page 13 is showing us, because you're talking about other sexual offenses.
The statement by a previous witness, I can talk about the data that I have access to and can analyze, and I can show you the outcomes of criminal court cases that have a child victim for those offenses that I can identify, which are it doesn't include sexual assault, because sexual assault you can't identify the type of the age of the victim from the criminal code section. And that's the way the data are collected in criminal court, is by section, subsection, and paragraph. So it's not possible to differentiate a young victim versus an adult victim using the court data.
Mais il y a des infractions.
But there are specific offenses of sexual assault or sexual assault involving a child. You're not able to give us the statistics specifically on those offenses?
Invitation to sexual touching, those offenses.
Ben, non seulement ça, mais
Well, no, not only that. I mean, sexual relations with young people right up to rape cases. I'm talking about all. I mean, we have some 20 sexual offenses that are dealt with in the bill, and they're all sexual offenses involving children. So you're telling us that you can't isolate them in the data that you have currently?
Any information on the victim for sexual assault using simply the information we collect based upon the criminal code. Okay. Section 271, 272, and 273 don't have any details on the victim. It's the nature of the offense, not the victim, that is included in the criminal code. So it's not possible to differentiate for sexual assault, other than using the data that we get from police services, which indicate approximately 53% are against young people.
Thank you. We'll go to Mr. Martin, Co-Martin, for 7 minutes.
I want to be confused with those other Martins, Mr. Chair. Thank you, Mr. Chair. Thank you, witnesses, for being here. I want to follow up on this because you're leaving some confusion. The initial data that you have here, it's on pages 5 through to about 9. That's all data relating to offenses against children.
Sorry, thank you. In the presentation, we have tried to show all of the sexual offenses committed against children that are the subject of this bill. So to go back to the point of Mr. Menard, if you look on the other sexual offenses slide, in the notes, you will see exactly which sections of the criminal code we are referring to and have included in those data. When you look at the information from the police, because we are looking at the victim side of the police reported data.
Let me stop you, Ms. McCullough, because again, we're short on time.
Okay.
As I'm reading that, these are reporting by the police, but they're not necessarily, those first 8 slides are not charges or convictions.
They're police reported data.
Right.
The only one the slide that is slide number 3 includes the child pornography, because those are offenses that we know about that have come to the attention of the police. However, for all of the other information that's looking at the age of the victim or characteristics of the victim, we cannot include child pornography because we do not have a victim record based on the police data that we have.
Okay. If I can take you then to slide, maybe that was the one you sent us before, the age of the perpetrators. What slide is that now?
Well, we have the age of the victims on slides 4 and 5.
I'm asking for the perpetrator.
The perpetrator?
Yeah. In the booklet you sent us on Monday evening, it was, I guess it was in the attendant ones. It was at the back. It was on page 14 of the material you sent us in the first.
That was for a presentation that we made to the Senate on child pornography and child luring.
So you haven't done, I haven't got that far into the attendant attached material. Is that in here?
No, we haven't provided it for this, but we can provide it later on if you would like.
Let me ask you a question about it then. You have a very high level of persons accused of sex offenses against children 0 to 17 years, and a very high ratio in the age group of 13, 14, 15, and 16, 17. Is there any change in that, or is that still the same? Those figures were as of 2008.
Sorry, it would actually help me if I could see the graph that you were discussing. I'm sorry. There hasn't been that much variation in the proportion, the rate per 100,000 population.
So back to what you gave us today, those age groups, are they reflected in this data that you've got here as to the police reporting, not the charges or convictions, but just the police reporting?
So the information that we've shown you here, you have the age of the victim, and then we haven't included anything on the age of the perpetrator or the accused individual. All we have done is on slides 6, 7, and 8, showing you the relationship between the accused and the victim.
Okay, then if I can go to slide 9, just so that I'm clear on this, 9 and 10. Those are sexual assaults and other sexual offenses against both children and adults.
The other sexual offenses are the offenses that are the subject of this bill that are predominantly against the children.
Okay.
The sexual assaults, as Mr. Grimes mentioned and I mentioned in my comments, we cannot distinguish the age of the victim based on the court record. All we know, though, is that based on police-reported information, about half of all sexual assaults in Canada in the last year were committed against children.
Okay. Mr. Chair, I'm a bit concerned because that material, I think, is relevant. The material that they sent us on Monday is relevant. I want to be sure it's in the record of this committee and the hearings of this committee. Is that the case now? Because it's not been presented by them. I'd like to put it in. The clerk has it because obviously she circulated it to us. But I'd like that in the record of this committee.
Well, I think
On
we
this
can... Do you have the material there with you? And you can make part of the record? It has been circulated to everyone at this
Copy, I'm not-
committee.
I don't want to give up my copy.
You don't, well, it'll be on the file. And
Just point out, the slide that he showed to us was actually 2008 data. We have more recent data than that. I believe that was a slide that we may have presented on last year.
Right.
We have more up-to-date information from 2009 that we'd be happy to present to the committee.
Mr. Comartin, would it be sufficient for them to provide each one of us with that updated data?
Yes, I just wanted to have it so that when this bill gets to the House, that I'll be able to refer to it.
You can provide it.
I'm saying to you, I need it fairly quickly.
Certainly.
I'm not
We
sure
do
you...
that quickly. No
I'm not
problem.
sure you need our permission to refer to it in the House.
Well, I want to be sure that this committee, that the House is aware that this committee had this information.
All right, we'll make sure that we circulate that information once we receive it, and we'll circulate as soon as we get it. All right.
How much time do we have?
You've got about a minute.
I want to stay with these offenses. After the same chart, I think it was 13, is there anything else in the data that's been reported to you that would show any other reason for the increase in the custodial rate? I'm on 13 now. And the drop in the use of conditional sentences other than the bill that was passed at that time that increased the penalties?
We would only be able to report on the actual numbers that you see. We wouldn't be able to make any inferences between any legislation that was passed and the impact that it had on the data.
Okay. And in the period of time from 2000 to 2005, just so we're clear, both with regards to custodial sentences and the use of conditional sentences, that was a fairly flat line?
Yes, I would say it's a fairly flat line. Some variation, but we can provide you with the actual data underlying it if you would like.
Okay, thank you. Anyone on the government side? All right, going back to Liberals. Any other questions? None? Okay. Monsieur Lemay.
Oui.
Yes. I have looked at the statistics that you sent to us, and I am very concerned. Because when we're drafting a wall-to-wall bill such as C-54 that we're preparing to vote on here, I'm very concerned about the number of offenses for the Yukon, the Northwest Territories, and Nunavut. And now, I'm sorry for my colleagues, I'm at page 3. So when I look at these figures, for Quebec, do you have the statistics for Nunavik, which is a northern area or region of Quebec, the far north, not Nunavut, Nunavik?
And look at the breakdown that we have. The RCMP polices that area in Nunavut, and we can look at a further breakdown.
OK. Ce que j'aimerais savoir, excusez-moi, ce que j'aimerais...
What I would also like to know is that you have offenses here that are from sexual offenses against children 0 to 17 on page 3. What I'd be interested in knowing is, if we go back in time, for the Yukon, the Northwest Territories, and Nunavut, is there a decrease in 2009? Is it staying stable, or has it increased? These the number of sexual offenses against children 0 to 17 years. And I'm speaking of those 3 territories, but obviously it also applies to Quebec, to the northern region called Nunavik.
Information to the committee, going back in time.
Mais vous n'avez pas avec vous pour 2008?
But you don't have it with you for 2008? You don't have that data with you? Has it increased from 2008, or is the trend being maintained? I don't know if you have that with you to 2007, 2008, because you said you have been keeping these data since 2000, from 99, 2000, but I have the impression that there has been an increase. I'd like to know if that's the case or if it's the same.
We don't currently have that information with us. We'd have to go back and look at our databases to see whether or not it would be possible to break it down by province and territory for previous years. Again, it goes into the methodology of the way we collect the information. We might have to look at a subset of police services to be able to provide that information to the committee by province over time.
And for some offenses, it may not be possible to break it out for a long period of time, because prior to 2008, a number of these offenses were grouped into a much larger category.
Je comprends parfaitement. Moi,
I understand perfectly. I'm not asking the impossible, but what I want to know is if you sense that there's a trend, given the new offenses being created and these new mandatory minimum sentences that we will be imposing. So, or at least that we're preparing to vote on. I'm not sure when that will happen, but I am very concerned about the situation in terms of prevention, because I heard what you said earlier, Ms. McCauley, and indeed it confirms to me that there would be an increase. But my question is, are you in a position to send us those statistics? You'll do the research. You'll be able to do so before March 1st. Because next week is constituency week, so if you could send us that information, then it would be perfect.
We will look at the data and provide you with any information that we do have available.
Merci.
Thank you.
Mr. Well, we'll go to Mr. Murphy and then Mr. Cole-Martin. All right, Mr. Murphy?
Yeah, and as I say, I apologize for not knowing this better, but a lot of what seems to create anxiety is the whole idea of luring on the Internet. There's some new offenses in here that respond to what are perceived to be problems, and I think they are. And it reminded me of earlier questions of earlier witnesses where there are many offenses in the code under this category of sexual offenses and corrupting public morals. What can you say? Can you break down? Are you able to break down the offenses by category specific to the section of the code? I assume you have to do that to put them in here as a total.
Yes, we do. So we would be able to provide you with breakdowns if you would like.
Appreciate that. Can you tell us off the cuff I know you put it all together, and that's a very interesting overview, but has there been I don't know, an increase in the crimes that involve the Internet, I guess?
We did a presentation either last week or the week before to the Senate Standing Committee on looking at exactly that. I don't have the slides in front of me and the background information, but I'd be happy to provide it to the clerk. Some of these are new offenses that have recently been introduced into the criminal code, such as luring a child via the Internet was introduced in 2002. We do see that the number of incidents, there is a trend in it. However, there's a few things that you would have to be careful of when you look at those data. The first being, it does take a while for police services across the country to start charging people with those offenses as it becomes more embedded in there. The other thing is that policing practices can have an impact on newer crimes that are related to the Internet. So the increase in offenses, we don't know, or increase in incidents, we don't know whether that is specifically related to increased activity or the creation of cybercrime units within police services across the country. So we can't detangle that. All we can tell you are the actual numbers, but we can happily provide that.
For criminal court, if you turn to slide 23 in the supplemental section of the presentation, the offenses that are included in the other sexual offenses are broken down, and those are the charges that are completed in court in the cases that contain at least one of those charges.
Well, child luring via Internet, I'm sorry I didn't see this before, is spiked quite a bit actually since its inception. That's the second last line?
What we can say based on those is that the number of charges of child luring via the Internet is increasing.
Yeah.
And this is different than police incidents. This is completed charges in criminal court.
Understood. Thank you.
We'll go to Mr. Colmartin for a quick question.
That'd be a quick one.
Well, we do have clause by clause.
I actually have a number of them, Mr. Chair. Just on the slide 25, you're showing the child pornography charges, and then on 26 you're showing the convictions. Any way of telling us what happened? I mean, we're getting, and I'm looking at the possession ones in particular. We're getting less than half convictions. Can you give us any indication as to how the other charges were disposed of?
Yes, I don't have that information in front of me, but yes, I can provide that information to the clerk.
Are you able to give us a general indication of what happened? Is this where they've been withdrawn, stayed?
Well, it would have been either acquitted, stayed, withdrawn, dismissed, discharged, or some other final decision.
You had used in the material, again, that you sent us on Monday, you had used some, in terms of disposition, an other category, which actually was fairly substantial, as I recall. What's an other category?
Are you talking about type of final decision?
Yes, disposition.
Okay, so for other final decision, it would include matters that were waived to Superior Court in those jurisdictions that don't provide Superior Court data, and there are very few right now. It would also include unfit for trial. It would include loss of jurisdiction, nullity. So there are very few in that category. Most matters are found either guilty, acquitted, stayed, withdrawn, dismissed, or discharged.
Well, actually, Mr. Grimes, they were fairly high in the youth court. The disposition was up fairly high. I think it was 15% or 16%.
Okay, youth court, there's a series of other decision types that are a result of the YCJA. So there's a much larger category in other for youth court.
Okay. There was a significant variation. You had done regional ones, mostly municipal regions, like Toronto and Hamilton. The Hamilton rate of charges was almost double, well, at least 50% higher, close to 75% higher than it was in Toronto. Quebec was substantially lower than Montreal, and there were St. John's in Newfoundland was about a third of what St. John in New Brunswick was. I'm trying to get some sense of what that variation was about, but it was quite noticeable. Any explanation?
All we can report on are the numbers that are provided to us through the police services and through the courts. We wouldn't be able to provide you with any indication as to why there might be that geographical variation. We do know that there is a fair amount of geographical variation in the number of incidents and the rates, depending on the offense coming forward.
I just have one more. I'm sorry, just with regards to the age factor again. You're showing this really large proportion of young people, the 14, 15, 16, 17, that age group. Is there any way of knowing, because you haven't broken down the adult sexual offenses from the children's sexual offenses in terms of who the victims are, is there any way of doing some kind of an analysis? You know, we've got a 17-year-old and a perpetrator and a 14-year-old. Is there any way of doing that?
Oh, looking at a age comparison between the victim and the accused?
Yes.
We would be able to do that for you.
How long would it take you to do that?
That's a little bit more complicated for us to put together, but certainly something that we could provide to the committee prior to March 1st.
Could you do that, please?
And just for clarification on our end, would you like that for all sexual offenses that are considered under this bill?
Just the ones under this bill.
Just the ones under this bill. Okay, we can do that.
All right. Monsieur Menard, you had another question, did you?
Oui, évidemment.
Yes. When you're talking about children, you're speaking about what age exactly?
At people 0 to 17 years of age.
Est-ce que c'est parce que c'est comme ça que les statistiques...
That is how the statistics are kept? They're compiled in that, with that bracket?
Any way that you would want. As you can see in the slides that we
Okay.
presented, we've been able to group 0 to 5, 6 to 11, 12 to 17. Depending on the subject matter, we'll just do 0 to 11, 12 to 17. So if there's data that you would like to see broken down in a different way, we'd be happy to provide it.
Non, c'est pas... J'ai regardé quelques dictionnaires.
I was looking at a few dictionaries, and most dictionaries would say that a child is between birth and puberty, that period of anyone's life. But obviously puberty is getting progressively, comes progressively sooner over the time, it seems.
We will either refer to them as children or children and youth. Children being up to 11, 12 to 17 being youth.
OK. Mais en tout cas, de toute façon, quand vous mettez 0 à 10...
Well, in any case, when you put 0 to 17, it's exclusively in that age group. The children who are up to 16, so 17-year-olds are no longer children?
Ah
So
bon?
it's 0 through to age 17, and including age 17.
And including 17.
Yes.
No? OK. Merci.
Thank you.
Suspend for 2 minutes so that our witnesses can be excused, and then we'll have justice officials take their place. So we'll suspend for 2 minutes, then go into clause by clause. reconvene the meeting. We're continuing our consideration of Bill C-54, and we're now moving to clause by clause. We welcome to our table representatives from the Department of Justice, Matthias Villatort, as well as Carol Morency. So welcome to both of you. Now, pursuant to Order 75, Standing Order 75-1, consideration of Clause 1 is postponed. So I'm going to call Clause 2. There are no amendments proposed to Clause 2. Yes. Monsieur Petit.
Monsieur le Président, est-ce
Mr. Chairman, would it be possible, I would like to have a recorded division for each clause, a vote on each one, please.
All right. We've received a request that we have a recorded vote for each one. Now, do you wish, if some of these clauses are grouped together, because there are no proposed amendments, are you satisfied with that if we simply do that as a recorded vote, or you want to do each one separately?
c'est parce que j'ai pas de la traduction. Oui, là, j'entends un peu, mais pas assez fort. OK, on va essayer. OK, allez-y. Oui, OK, good. OK.
Okay, now it's fine. Yeah, go ahead.
The question is, you've asked
Mr.
for a
Chairman,
record-
on a point of order.
All right, point of order
Could
from
you
Mr.
just
Lee.
clarify who will speak for the government on this bill as we proceed to clause by clause?
I believe it's Mr. Deckert. Mr. Deckert, is that correct? Or Mr. Petit?
Mr. Deckard is shaking his head, so
I said or, either myself or Mr. Petit.
that's fine.
Right.
Either one, just want to know who it is.
Yeah, either one, apparently. I'm going to go back to...
I'd like to speak to that point of order.
you do? Okay.
Just briefly,
Mr. Woodworth.
because I want to make sure I understand the process. I assume the fact that a parliamentary secretary may speak for the government doesn't prevent me from speaking if I choose to do so.
Not at all.
Thank you.
Not at all. All right, Monsieur Petit, I just wanted to clarify. We're going to have a recorded vote on each clause. Some of the clauses we may want to group together with the unanimous consent of the committee. If that happens, are you okay with that?
No.
No, you want to have...
No.
All right. Okay.
I want to hear from Mr. Decker.
That's okay. So I've called Clause 2.
Point of order. Point
Sorry,
of order.
we have another point of order. Ms. Jennings.
Just on procedure, is the simple request by a member to have recorded vote on every single clause sufficient? There's no vote, it just happens because a member asked that.
That's my
Or-
understanding, yes.
That's
If
the
a member
procedure?
requests it, it's incumbent upon the chair to allow that to happen.
Okay.
Yeah, Monsieur Petit?
Monsieur le Président, je reconsidère.
Oh, Mr. Chairman, I'm reconsidering my request, because indeed, if it is possible to group together clauses, we could have a single recorded division on a group.
So it's much more efficient. Thank you for that. Is there anybody else who want to comment? Mr. Comartin?
Are we dealing with Article 2?
Yes, I called Article 2, then we had some discussion, so I asked, yes.
And I'm going to want this and a number of others. I tried going through all of them, and I just ran out of time. And then several I couldn't understand what we were doing with these, and this is one of them. What we're doing, just a quick explanation from the officials as to what the effect of this will be in terms of adding it to 7 bracket 4.1 of the code.
So Clause 2 of the bill is amending the provision that we commonly refer to as the child sex tourism provision in the Criminal Code. This provision provides Canadian authorities with jurisdiction to assume, extraterritorial jurisdiction to assume an investigation and prosecution of a Canadian citizen or resident who travels abroad and commits one of the enumerated offenses which, if they had been committed in Canada, could have been charged and prosecuted here. So that law has been in place since 1997. So what Bill C-54 is doing is adding the new offenses to the provision. So we're adding the two new offenses being proposed by C-54, as well as some other housekeeping, because with C-54, we're trying to ensure consistency across the board. So the provision would also be broadened to add in the offense of Section 171, householder permitting sexual activity, as well as the luring a child offense, which is currently a criminal code offense but not listed in the section before you, as well as the two new offenses. So with this, the intention would be that if a Canadian goes abroad and commits one of these four offenses that are not now listed, it is possible for a Canadian prosecution. Again, it's always subject to whether the Canadian is charged and prosecuted for that offense abroad. If not, a Canadian court could assume that jurisdiction.
All right, Clause 2. Shall Clause 2 carry?
Yes.
All those, well, actually, we need a recorded vote.
Microphones, please.
Say yea. All those opposed, please say nay when your name is called. Mr. Deckard.
Yes.
Mr. Norlock.
Yay.
Mr. Pitsy. Mr. Rathgeber.
Yes.
Mr. Woodworth.
Yes.
Ms. Jennings.
Yes.
Mr. Lee.
Yes.
Mr. Murphy.
Yes.
Mr. Lemay.
Oui.
Mr. Menard.
Oui.
Mr. Comartin.
We.
Clause 2 carries. Move on to Clause 3, and we have a block amendment, which you have in your package. Monsieur Menard, would you like to introduce that amendment?
Bon,
I would like to say very clearly at the outset what I'm intending to do here. What I have done through my study and the testimony that I heard have convinced me that this bill overall is a good piece of legislation. And unusually, I am prepared to admit that mandatory minimums are, in this case, a legitimate objective because, first of all, we're talking about children, we're talking about the most vulnerable victims, and they're also victims of sexual offenses, and any offense against a child have the most serious and long-term effects and repercussions. And it's also because I accept the fact that in any case where there is a mandatory minimum, indeed, there is the need to really condemn the crime and to have it impose a punishment and to really shock the person who's committed these offenses. And that's important. Even if we know that in certain cases it will not have any influence on the risk of that person reoffending. But in those cases, the punishment is even more justified. So clearly, and I've said it in the study of many other pieces of legislation, that I am generally biased against mandatory minimums. And in other circumstances, I have shown what a terrible direction that takes us into, or where that has taken countries who have systematically adopted mandatory minimums. But as I said, we're not doctrinary in our opposition here, and we are prepared to recognize mandatory minimums when they're justified. And in this case, we do feel that it is the case. So I've done an attentive study of this bill to have seen that it has been very carefully conceived in order to adapt so that there is really a real rationale between the minimums that have been chosen through summary procedures or upon conviction as to the seriousness of the offenses that are targeted here. So this is a very broad scope. it goes from 15 days to 5 years. And when it's an issue of 5 years, that is indeed for sexual offenses that are armed or with violence, and incestuous sexual offenses involving children under the age of 16. And once again, the testimony that we heard with the witnesses that we heard last Monday, and some I had consulted well in advance. I accept their logic, particularly Mr. Van Gisegen, who said that even if it is strange, there are children who manage to come out of these effects or these events. Reoffending in terms of incest is not so high, but the effect on the victims is profound. And so in many cases, the minimums have been very well crafted and measured to look at eventual offense by the offender. And also, of course, taking into account the gravity of the offense. Now, however, one of the things that always worries me with mandatory minimums, and not just that worries me, but in my experience as a practitioner since 1966 in terms of criminal law, and the experiences that I've seen in other countries where there are mandatory minimums, it is such that judges in some circumstances are not able to hand down the sentence that they would feel to be fair and right. And sometimes it's because we haven't taken into consideration sufficiently the cases that would justify, or that would indeed not justify, the mandatory minimum that the judge must hand down. In other countries of the Commonwealth, as is the case in certain American states, there are clauses that provide, indeed, when there are extraordinary circumstances that the judge finds, he is not obliged to hand down that mandatory minimum. And this is, of course, with the condition of very carefully explaining what those reasons are, that the judge feels handing down the mandatory minimum would be inappropriate. So this has the advantage of not obliging the judge to hand down a sentence that he feels to be unfair, but at the same time it has the benefit, when we look at the use of this clause, if we want to see whether or not these mandatory minimums are fair or not, it allows for a review of this when these clauses exist. And so this is for exceptional circumstances, unusual circumstances, and they're difficult to foresee. But if there's any area in which it may happen, it would be in the case that we are currently studying. So I understand perfectly well the mandatory minimums that are provided for in 151A and B. And I know what we're targeting here. I know what the intent is. We're looking at sexual interference and touching of children. And most of the time, when these cases are revealed, it has been an ongoing event. And there will be very significant effects on the child and their development, and then the suffering that this person will continue to have for a good portion of their life. However, it is impossible to describe that offense without covering, and that's what we're doing here, the very infrequent occurrence of this offense. As you know, the true experts came and testified here, these people who have spent their lives working on these matters, Mr. Ginzigan, Mr. Quincy, pardon me. And we had the impression that they were able really to help certain people. A lot of children are abused by pedophiles in 20% of the cases and in 15% by psychopaths. But for the people who don't correspond to those characteristics, who have that tendency, it's important that we be able to punish them under the law and to discourage them from ever doing that again. And the rest, this is what the rest of the legislation is intended to do. But someone who begins touching children with a sexual intent for a certain period of time, where really the decision has been made to do that, doesn't deserve, well, rather, it does deserve a mandatory minimum sentence. But we can see that, say, at a party, someone who's never committed any offense, someone who perhaps of having too much alcohol or something, or even in other circumstances, it could be in a situation where the people are more or less of the same age, and for having sexually touched the person once, it wouldn't be justified to send that person to jail with the mandatory minimum. And there could be other circumstances that the judge could take into offense. So in all of the offense or circumstances that I really looked, this is the only one where I see a real possibility of a judge feeling that the mandatory minimum sentence would be unfair and non-productive. So I'm moving this amendment only in the case of this sexual touching or interference. Now, when a youth is invited to participate in this, there might be a more serious result rather than one isolated event. So I asked the lawyers who drafted this to look for inspiration to other jurisdictions or administrations that have similar clauses, and that is why it is in the form that it has now. That the court could impose a sentence of detention of lesser duration than a minimum punishment of imprisonment if it is the opinion that compelling circumstances relating to the offender or the nature of the offense warrant it. If the court does impose a sentence of lesser duration, it shall provide a written statement of its reasons at the time of sentencing and include it in the record of the hearing. There's something else I'd like to say later on, but in the case of this, most unusually, my party and myself feel that we accept that this would be one of the rare cases where mandatory minimums are generally acceptable and justified. So there are the two extremes here. We have mandatory minimums that I find acceptable in cases of murder, because that is the most serious offense, and it affects victims the most, obviously. And the other end of the spectrum, with short minimums for recidivists, when there are people who repeatedly commit the same offenses, like drunk driving or driving under the influence of something, and that mandatory minimum might really have an effect on the person's behavior. So with the driving under the influence, the minimum is 15 days. The second offense, it's 90 days. And there we've seen studies done by criminologists that I have seen over 30 years. That really can have a deterrent effect, because there the conviction after the first time, the person must be warned that the next time there will be a minimum. But here, it's really because of the effect on the victims. And because we're talking about children. The other thing we learned is that whether a person's imprisoned or not, whether they have treatment or not, it is first and foremost very difficult to determine treatments that will actually ensure that people do not reoffend. And it's very random whether there are positive effects or not. And that's why there is a need for this, and I think that offenders really need to have a real shock here, and they need to know that they cannot start doing this again. So I think that is generally the case in the society in which we live, and I think in all societies in this world, that the protection of children from this kind of offense is as important as anything. Thank you.
Thank you for the introduction to your amendment. I do have a draft ruling for the chair, from the chair, before the rest of you intervene here. It's a ruling, not a draft ruling, it's a ruling. Bill C-54 amends the criminal code to increase or impose mandatory minimum penalties for certain sexual offenses involving children. This amendment proposes to allow for the court to exercise its discretion and select a lesser punishment than the minimum provided for by the bill. As House of Commons Procedure and Practice, Second Edition states on page 766, and I quote, "An amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill," end quote. In the opinion of the chair, the introduction of the concept of discretion is contrary to the principle of Bill C-54 and is therefore inadmissible. So that's my ruling. Monsieur Menard?
Oui. Bon,
I anticipated that you would give me this argument, but I don't think that it holds water, because we can very well have the opinion that this should be eliminated, except that...
But it is challengeable, yes. Mr. Murphy, you want to challenge the chair?
I do. I want to just make a motion to challenge in that this act is called the Act to Amend the Criminal Code, Sexual Offenses Against Children, Protecting Children from Sexual Predators Act. There's nothing there that speaks of mandatory minimum sentences. So therefore, I challenge the ruling. I gather it's not debatable either.
It's not debatable. So the question is, shall the ruling of the chair be sustained? Recorded vote?
All those in favor, please say yea. Those opposed,
Make one comment?
No, there's no debate.
please say nay. Shall the chair's ruling be sustained? Mr. Deckert?
No. Oh, sorry, yes. Sustained. I apologize.
That was a shock.
My apologies. Yes, he should be sustained. It's correct.
Mr. Norlock? Yea. Mr. Petit? Mr. Rathgeber?
Yes.
Mr. Woodworth?
Yes.
Ms. Jennings?
No.
Mr. Lee?
No.
Mr. Murphy?
No.
Mr. Lemay?
No.
Mr. Manaw? Mr. Comartin?
No.
So the ruling of the chair is not sustained. Therefore, we'll continue debate on it. We have on the list Ms. Jennings.
Thank you. I'm pleased to be able to speak to this amendment. I wish to announce that Liberals will not be supporting this amendment. We do believe that it was and is, in fact, within the scope of the bill. However, it was Liberals in previous governments that established minimum mandatory sentences for these sexual offenses that we find currently in the code, in the criminal code, and which the current government wishes to raise. We are in favor of minimum mandatory penalties in very targeted areas, and one of those areas, as everyone knows, are firearm-related offenses, for which we brought in minimum mandatory penalties, and we're also in favor, as the fact with the fact that there are minimum mandatory sentences for sexual offenses committed against children, and the proof of that is that the existing minimum mandatory penalties for those type of offenses, which the Conservative government now wishes to increase, were in fact brought in by Liberal governments. So we will not be supporting this amendment of the bloc.
Thank you. We'll move on to Mr. Rathgaber.
Thank you, Mr. Chair. Very briefly, I too will be voting against this proposed amendment. With all due respect to Mr. Menard and his nearly half a century in criminal law, his reasons for introducing this amendment are counterintuitive to what the amendment says. He talks about the need for mandatory minimums and how he's not doctrinaire in his opposition to mandatory minimums, but then he introduces an amendment which essentially allows a court to ignore mandatory minimum sentences if, in the opinion of that court, there's compelling circumstances to do so. I'll be voting no.
Thank you. We'll move on to Mr. Comartin.
Well, I'll be supporting the amendments. It's one I actually have a private member's bill on the same issue, which I derive from the experience in England that have exactly this type of provision I think it's a general provision in their whole criminal justice legislation that, given exceptional circumstances, the judiciary has an ongoing judicial discretion, even when there are specific penalties, whether those penalties be minimum or maximum. So it's, although I hear the argument about it being counterintuitive, in fact, it is the practice in England, has been for at least a decade now. But, Mr. Chair, I do have one question, just so we're very clear on this. I know Mr. Menard sees this as applying only to Section 151. Just wonder from the officials if they agree with that, if there's any way this can be interpreted as being applied to any other sections in this bill.
I would have two comments to make. Firstly, the amendment is being proposed simply to Section 151. So the obvious interpretation is that the discretionary clause, if it were passed and enacted, would only apply to Section 151. My second comment, though, would perhaps speak to some of the background offered to the motion, which is just to clarify. Section 151 does require, it is what we call a specific intent offense. It does require the Crown to prove that the accused touched a young person under that age for a sexual purpose. So it doesn't apply perhaps in the situation described as a general accidental touching. So there is very much with this offense, it does clearly apply to a specific touching for a sexual purpose of a person under the age.
And then a follow-up. If I'm reading this correctly, the near-age defense, the 5-year near-age defense, applies to this section. So if a person who touches directly or indirectly, et cetera, is 19 or up to age 21, somebody who's 16 or younger, or under 16, that would not be an offense.
That's correct. Bill C-54 does not change anything in the criminal code as it applies right now to what we refer to as the age of consent and a close-in age exception. So it does apply. So if a person is over the age of consent and engages in consensual sexual activity, it's not an offense. If the person is below the age of consent, 14 or 15-year-old, and the other person is less than 5 years older, not an offense if it's consensual.
Okay, we'll go to Mr. Murphy. You're on the list.
Oh, I don't think so.
Okay. We'll move to Mr. Deckard.
Thanks. Just briefly, I will also be voting against the amendment. I acknowledge that the previous Liberal government did impose mandatory minimums for these sexual offenses. I agreed with that amendment at that time, and I agree with the government's position that those mandatory minimums need to be increased. We believe, the government believes, that every person who, for a sexual purpose, touches directly or indirectly with a part of the body or with an object any part of the body of a person under the age of 16 should serve some time in jail. And on that basis, I will not support Monsieur Menard's minimum or amendment. It seems to me that he is essentially trying to remove a minimum, and that really flies directly in the face not only of what the government is trying to do here, but what the previous government did with respect to these provisions.
Thank you. We'll move on to Mr. Woodworth.
Thank you very much. I'll begin by saying that I'm very heartened and hopeful as a result of the comments that Mr. Menard has made and what appears to be a sincere expression of the fact that his heart has been touched by the pleas of the victims that we so often hear at this committee who support mandatory minimum penalties, at least that his heart has been touched by the pleas of victims of child sexual assault. And I'm very grateful to him if he has now seen his way clear, as he says he does, to support a mandatory minimum penalty and even to use his considerable powers of persuasion to convince the rest of his caucus to support them. However, I believe that his pen has betrayed his heart. And that somewhere between his resolve to accept mandatory minimum penalties to protect the victims of child sexual assault and the drafting of this clause, his pen lost its way, because this clause, of course, is not a mandatory minimum penalty. A mandatory minimum penalty which is not mandatory is not a mandatory minimum penalty. I wish I could say that in French to be sure that the translation is clear. So I was happy that Mr. Cromartin clarified for Mr. Menard that the close in age exception will protect perpetrators that Mr. Menard was concerned about, and I was happy that the Department of Justice official clarified for Mr. Menard that, in fact, this is a specific intent section so that an accidental touching does not need any protection from a mandatory minimum penalty. There will be no conviction. And I hope that Mr. Menard will vote with his heart and accept the clause as a real and true mandatory minimum penalty. I'm certain that the people of Quebec, I have a great admiration for les gens de Quebec and their intelligence, and I'm certain that the people of Quebec will know that a mandatory minimum penalty which is not mandatory is not really a mandatory minimum penalty. I respect their intelligence enough to see through that, and I'm sure that Mr. Menard will too. Thank you.
Thank you. Anybody else? And we'll go to calling the question on BQ Amendment number 1.
All those in favor, please say yea. All those opposed, please say nay when your name is called. Mr. Deckert.
No.
Mr. Norlock.
Nay.
Monsieur Petit.
No.
Mr. Rathgiver.
No.
Mr. Woodworth.
No.
Ms. Jennings.
No.
Mr. Lee.
No.
Mr. Murphy.
No.
Mr. Lemay.
Oui.
Monsieur Menard.
Oui.
Mr. Comartin.
Oui.
The amendment fails. We'll move now to Clause 3 as unamended. Mr. Lee, I understand. Do you want to
I have a question. This particular dual amendment increases the penalty, the mandatory minimum penalty under paragraph A. It increases it from 45 days to 1 year, and paragraph B, summary conviction, from 14 days to 90 days. And my question is to government officials, and I'm bearing in mind that the Statistics Canada data we just got shows that we have, over the last 10 years, some 7,000 convictions for sexual interference. And each of these convictions, where the mandatory minimum would be used by the court, would send a person to a provincial institution, not a federal institution. By definition, 1 year and 90 days. Those are provincially served, not federally. So there's a full imposition of the cost of this on the provinces. So my question is, has the department done a workup on what this might cost provincially? And two, has there been any consultation with provincial counterparts in relation to these before we go ahead and impose it on them? And if Ms. Morency or Mr. Villatort, you can't answer that, perhaps Mr. Deckard can.
Well, as the question has noted, yes, the time proposed, the increase does remain within the less than 2 years, which does remain within provincial time. So what Bill C-54 is doing is adding to what is already there. In the sense of have officials done an assessment of what the implications might be? Yes, we have, and that information was provided and is based, and the decision you see is reflected in the decision, the bill before you. I am aware that there is the motion on costs for crime justice bills, and that is being debated in the House, and that might be another opportunity to get the other information more specifically. And no, we did not. In the course of developing Bill C-54, there were not specific consultations on that. However, that said, it is fair to say that over the course of the work that we do in the area of criminal law reform, we do work closely with our provincial territorial counterparts, and over the years, it's generally fair to say that there is support for measures to strengthening criminal law responses to child sexual abuse. Where there is disagreement, whether it's here or it's in other fora, it tends to be how do you achieve that. But that said, there's generally support, but we did not consult specifically on C-54.
Thank you. I will then move to Clause 3. Oh, sorry, I didn't notice your hands.
Well, maybe the same first.
Mr. Murphy? Mr. Murphy first, and then Ms. Jennings.
Okay, just to follow up, what I thought was not as specific an answer as I would have liked to Mr. Lee's question. Paraphrasing you, you said you did an analysis and you provided that material, presumably to officials in the Department of Justice who made a policy decision. I understand that. Did the research or material that you asked include a costing? I think his question was fairly specific. I didn't hear you say including costing, and I just want to be clear on that.
Well, all matters that whenever there's a matter that goes before a cabinet for decision on whether to come forward with reforms or a package or response of some sort, obviously the cabinet is informed by all of the analysis that's available and required to support that decision. But I'm obviously not in a position to advise this committee of a matter that is a cabinet confidence.
Look, just to follow up on that, I'm not satisfied with that answer either, because no one is asking you to betray cabinet confidence, and nobody's asking you at this point to provide the figure. The question is, were figures provided to the government?
Yes, the matter was costed out, and yes, the advice is provided to inform the decision. But as I've already noted as well, that the bulk of the reforms that are presented or proposed in Bill C-54 do fall within the areas of what's already there in the criminal code now for mandatory minimum penalties. So increasing from 14 days to 90 days, there is an increase within that time frame, but it's...
Yeah. That's fine, thanks.
Thank you. Next, we have Ms. Jennings.
Ms. Jennings, sure.
Ms. Jennings, and then we have Mr. Cole-Martin.
I just want to make sure my colleague has finished speaking to his amendment.
I know we're on the clause. We're not on my amendment yet.
We're on the...
Oh,
No.
Ms. Jennings, we're on the main motion right now.
Clause 3.
Main
Clause
motion.
3. Clause 3.
Okay. I don't have anything to say on that.
All right. Mr. Cole-Martin and Mr. Lee.
I just want to do a follow-up to Mr. Murphy's question in terms of the information that was given. Was the analysis for both the increased incarceration rate at the provincial level and the federal level? Because there's at least one section where on incest, it's a 5 years, so that they would end up in the federal prisons. Was it done at both levels?
Well, obviously, federal responsibility is within federal corrections. So looking at what implications there might be, we're not in a position to cost out provincial implications.
So it was just done at the federal level of incarceration?
Yes.
I'm sure this is relevant because almost all of I'll ask it anyway. I'm not sure how you were able to do that, given the information we got from Stats Canada today, where they weren't able to separate out the sexual offenses, adult ones, from the youth ones.
Point of order, Mr. Woodward.
Yes, I'm not sure if I'm following the thread of this, but I thought I understood the witness to raise an issue of cabinet confidentiality earlier, and it sounds like Mr. Cromartin is asking about the same information. And if I'm right that he is, then I would think that the same issue of cabinet confidentiality is going to arise on all of his questions about it, and the witness ought to be protected from having to receive questions which might result in a violation of cabinet confidentiality. So I'm asking you to rule his questions out of order.
Well, I don't think his question is out of order. The witness has made it very clear that she will be protecting cabinet confidentiality. She's a very capable, highly intelligent individual who I know will not cross that line. So I'm going to allow Mr. Cromartin to continue.
Yeah, and I'm not obviously asking you to tell me what the result was. I just don't know how you could have done an analysis, given what we heard from StatsCan today, when they couldn't differentiate because of the way the reporting is between adult sexual offense, victims who are adults and children who are victims. Between those, I don't know how you'd have been able to do it. So I may have missed something. That's really what I'm asking. Is it possible to do that assessment?
Well, just to clarify, in terms of the statistics that we just heard about, we obviously have access to the same statistics that the committee has heard. We have access to older reports as well. The committee heard that there is a difficulty for adult criminal court survey data to break down the number of general sexual assault offenses that involve child victims as distinct from adult victims. And that's a challenge that I have little control over in terms of trying to provide better information to this committee. However, I did provide to the committee, as part of one of my undertakings from my last appearance, I did provide the committee with the child and youth victims of police-reported violent crime from 2008. It was released in 2010. And this is a document that's produced by the Canadian Centre for Justice Statistics, and it does say in there, vis-a-vis the three general sexual assault offenses, Section 271, 272, 273, that they did provide a number in here that broke it down that children were the victims in approximately 80%, or 80% of the cases that proceeded against child victims proceeded under those three general sexual assault offenses. I'm not able to provide any further breakdown to the committee, and neither is CCJS. But that does give some sense of, for example, the implications of proceeding under Section 271, how many child victims are there. And the minister made reference to that same statistics when he appeared. The other statistics that CCJS just provided to the committee, when it deals with a child-specific offense, is very easy to identify. This is clearly affecting a child because you have an age criteria. The challenge was, I think, from one of the questions was, what's the age of the offender and how do you get that? So what we do, we look at what are the number of offenses, incidents reported, number of offenders that are convicted of a particular offense, and perhaps what data exists in terms of what's the average length or the median for the different penalties or sentences that are imposed. So we do look at that, and the committee would look at it, for example, before you right now, the presentation you had just before this, where you see the number of incidents reported by the different child-specific offenses. That would give the committee an indication of what kind of change have we seen over the number of years? How many offenders are there being charged, processed under these different offenses? So you do have some parameters from that data, which we use as well. And of course, federal corrections, as would provincial corrections, they can look to their own inmate population and calculate based on their own actual numbers.
Thank
But
you.
that's not for me.
And do we know if they've done that province by province on this bill? Like, is that information? I guess what I'm really asking, is that information shared with you from the provinces if each province has done that?
No, my answer before was that within the areas of federal responsibility, calculations of costs would be to those areas of federal responsibility, federal corrections.
No, I understand that, but what I'm asking is if a province has, if Ontario did do the assessment based on this
I'm not
bill,
aware if provinces have.
They don't share that with you.
Sometimes it does happen. There's no question that we've had opportunities in recent years to engage in discussions through existing FPT fora, but I'm not personally aware of issues having been identified through that FPT fora on Bill C-54. And it's been out since November, and we have had various FPT meetings.
All right. Mr. Comartin.
Yeah, those are just questions. In terms of comments on this section, I think it's the problem we've got in terms of trying to assess this. The points that Mr. Menard made earlier about the difficulty of, taking a cookie-cutter approach, especially since all parties supported this legislation, the earlier mandatory minimums, including the Bloc at that time. And then when you look at the statistics of what we're seeing, that and the evidence that you heard from just about all the witnesses, that these types of offenses should result in jail time. The stats show that, in fact, in the vast majority of cases, they do result in jail time. But the real issue, and that's really what it comes down to with regards to the psychologists who have spent their whole careers working on these files, that it really is significant that I think it's absolutely mandatory that the sentence fits the individual. And so when you go with these, where you just try to fit everybody into one box, it just doesn't work. So having said that, Mr. Speaker, Mr. Chair, I'm obviously not going to be supporting these mandatory minimums in this case.
Thank you. We're going to go to Mr. Lee and then Mr. Murphy.
Thank you. There was reference made to cabinet confidences, and Parliament doesn't force cabinet to reveal cabinet confidences for reasons that we all understand. It could, but it doesn't. And but just because a weather forecaster somewhere gives a weather report to the cabinet doesn't mean the weather report becomes secret document. So the data is there, and it doesn't have to come from the cabinet. So I want to ask Mr. Deckard, who will try to speak for the government, if consultation was had with the provinces, whose provincial reformatories would bear the burden of this 6 to 7 times increase in the mandatory minimums on this section alone, if there was a consultation, and if there is a workup on the additional incarceration costs related to that, which would be imposed on the provinces. Simple question, and if I'll just ask it to him. I'm happy to have whatever answer it is, yes, no, or maybe.
Mr. Deckard doesn't have to answer, but he may if he wishes.
Well, he's speaking for the government. I think he should answer. If he doesn't answer, then we don't have someone speaking for the government.
I'm not aware that I'm a witness.
You're not a witness.
Okay.
I can confirm
so I don't know why I'm being asked a question by Mr. Lee. I know Mr. Lee purports to be an expert in the rules of committee, so perhaps he could explain why it's appropriate in his vast 22-plus year knowledge of parliamentary procedure, why it's incumbent upon any other member of a committee to answer questions that one member may pose.
Well, I guess at this point, Ms. Morency is speaking for the government. She's a government official. But all throughout the history of Parliament, it is ministers who speak in Parliament for the government. In fact, your own government has made this point more than once and in writing. It is ministers that speak for the government and not public officials. And we are deliberating, passing clause by clause a government bill here.
Mr. Lee,
and
the
if
minister
there's no one speaking for the government, if there's no one speaking for the government, then I don't have my ability to ask the question of the government. And earlier in this meeting, I asked who was speaking for the government, and I believe the responsibility was divided between Mr. Deckard and Monsieur Petit. So I simply asked the question of the person that I believed was representing the government. If there's nobody speaking for the government here beyond Ms. Morency, then let the record show that.
Let's be fair. Let's be fair. I believe what Messrs. Petit and Deckard indicated, that with respect to this legislation, the position on each of these clauses is being articulated by those two individuals. I don't believe there's anything to compel Mr. Deckard to answer questions. I don't believe that he is here representing the minister in the sense that he is a direct conduit to cabinet. Ms. Morency correctly stated that she was in no position to disclose cabinet confidence, and I think we all understand why that's the case. I think we want to respect that. Now, I want to go to Mr. Murphy. You've got a question. Mr. Deckard.
For 1 second. I just think it's worth noting, and anyone watching should note, that the Minister of Justice was, in fact, before this committee on this bill, and Mr. Lee had an opportunity to ask him any question he wished. And in further, I'd just say that my understanding of the information provided by Statistics Canada earlier today on page 13 noted that there was a significant increase in custodial sentences for people convicted of child sexual offenses following the enactment in 2005 of mandatory minimum penalties, as Ms. Jennings pointed out earlier under the previous government. I wonder if perhaps they could provide the information on what the additional cost of that was, and perhaps they could also provide the committee with the answer to the question as to whether or not they supplied that information at the time that legislation was being debated in Parliament.
All right. I think what we want to do is get back to the clause at hand. Mr. Murphy, it's your turn.
On the unauthorized undertaking, when we're back in government, we'll give you those responses. But back to this, really, what it comes down to, I didn't put a time limit on it, did I? But what I would like to know is basically what we've got here is, through volition, and I have to respect a member of the committee, not answering a question that is in the air, how much will this cost? Whatever reason, that's fine. I've got to respect a member of a members of a committee for that. I think the chair is correct on that. There's no compelling the parliamentary secretaries, two of them in the government, to do so. But I can't understand, Ms. Morency, why you can't tell us what the figures are, because you know what they are. And you're not disclosing cabinet confidence, because once it gets to cabinet, it becomes cabinet confidence. But your department had... but anyway, we'll leave it there, I guess. Is that the point?
Point of order. Vote is called, Mr. President.
Sorry. Unless we have consent. Yes, you had the floor. Someone indicated that the bells are ringing. Yes. Unless we have consent to continue, I will have to adjourn.
No.
There's no consent. We're adjourned.
Merci.